Good morning. Thank you for joining this very first AMCHAM webinar of 2021. We have a huge audience today, and it could be a record participation. This goes to show you how important this topic is. I am so excited to continue AMCHAM's digital transformation. It is hard to believe that just 1 year ago, our chamber never had an online event of this nature. Since the outbreak of the pandemic, we have now had over 30 webinars. It's been an amazing journey to see the creativity and passion of the AMCHAM ecosystem, especially through our new online platform. It is one major reason why AMCHAM saw record growth in membership last year, despite this very difficult environment. We look forward to many more virtual events that will ultimately help the AMCHAM members. Today's event is titled CEO Risks Navigating Through New Challenges. We owe a great deal of gratitude to our member company, Yoon Yang. They have brought a powerful lineup of speakers who will give invaluable guidance affecting executives of all companies in Korea. I call it truly priceless. My special thanks go to our moderator, Henry Shin, a senior foreign attorney at Yoon Yang, who's also an expert in corporate law. He has extensive experience in and outside of Korea. I also want to thank Edward Dong, senior foreign attorney and co-chair of the Compliance and Ethics Committee. Every company in Korea has to grapple with the issue of CEO risk. I think we're all very aware of some of the headlines that have sharply amplified the relevance of this issue. Prior to AMCHAM, I was also CEO of several US companies in Korea. And whether you're managing a few hundred employees or more than 10,000, an executive in Korea has to be very conscious of a much higher level of personal liability than his or her counterpart in the US. This level of risk is an important factor that impacts business plans, investment decisions, and human resources. It can even affect the decision to actually take the job as a CEO. There can also be a situation where the local CEO faces a conflict with the US headquarters. Today, as Korea undertakes major regulatory changes, it is critical time now for the global business community to understand what these changes are and to ultimately be prepared. For AMCHAM, helping US companies operate in Korea is one of our top missions. We are actively discussing some of our suggestions with the Korean government. These suggestions should lead to higher economic growth, better jobs, and much more opportunities for everybody. So once again, thank you so much for joining us. I also want to thank again Yoon Yang and to all of our speakers. I look forward to a great event, and I'm also looking forward to learning about this very important topic. Have a great morning.
Good morning, welcome. Thank you, Jim and AMCHAM, for this opportunity, and we would like to also thank all of you for joining us today. All of us have affected by COVID-19 in 2020, and companies are no exceptions. Many companies are going through a very difficult time, and also many companies have slowed down their operation. However, the Korean government and Korean lawmakers have been very active in enacting new laws and amending existing laws. These changes have a significant effect on how global and multinational business operates in Korea. As you are aware, Korea has a dual criminal punishment system. This means that not only company is criminally liable, individual like you, executive, can also be criminally liable. We hope to provide you with insight to these changes so that you could better protect yourself and your company. As Jim mentioned, we'll present 3 different areas of law of interest to you. First will be on antitrust, second on the employment law, and lastly on EHS. During our presentation, if you have any questions, please use the Q&A button at the bottom of your screen. We're trying to answer them at the end of our presentation. For the first time in 40 years, the Korean lawmaker has completely rewrote antitrust law. This will have a significant impact on how you operate in Korea. For this important subject matter, Charles Kim, who's a partner with 23 experience, will make this presentation. Charles' main practice area is antitrust. He has handled many high-profile cases and has provided legal advice to predominant multinational companies such as Qualcomm, Nike, and Bosch.
Thank you for your kind introduction. I am very pleased to provide an explanation about the recent complete amendment of the MRFTA, the Korean Antitrust Law. Table of contents, overview, exchange of information, merger filing, injunction, administrative fines, criminal punishment, and defense right. If you have any question about my explanation, please ask your question after the remaining topics finish. Let me start overview. The Monopoly Regulation and Fair Trade Act was enacted in 1980 and was partially amended several times thereafter. As you may know, the Monopoly Regulation and Fair Trade Act is the basic and most important antitrust law in Korea. The MRFTA underwent its first complete change on December 29, 2020. This amendment will become effective on December 31st, 2021. Key aspects of the amendment. First, exchange of information deemed cartel activity and thus prohibited. Second, merger filing required for mergers with large transaction value, even with a small target company. Third, private persons given standing to file injunctions. And administrative fines increased by twofold. And criminal punishment removed from some violations. First, prohibition of exchange of information. The MRFTA enumerates types of cartels that are prohibited. This is different from the US or EU laws, which have comprehensive rules regarding cartel activities. In contrast, the MRFTA enumerates types of cartels. There are 8 types of cartel activities under the current statute. Price fixing, colluding on terms and conditions other than price, restriction on output, market allocation, restriction on facilities, restriction on product kind or standard, joint execution or management of core portion business, and bid rigging. Exchange of information does not establish a cartel itself, but rather may only be evidence of a cartel. The Supreme Court holds when competitors exchange price information, it may be strong evidence of cartel, but such fact by itself does not automatically lead to the finding of price fixing. And therefore, in order for exchange of information to constitute a cartel, there should be additional factors such as a change in price that results in similar pricing. But under the amendment, exchange of information is regulated as an independent type of cartel. The new act provides for conduct substantially restraining competition in a relevant market by exchanging information on price, output, or any other information prescribed by a presidential decree. As such, exchange of information on price or output is prohibited. And other information, the exchange of which is prohibited, will be prescribed by a presidential decree. And therefore, companies must practice caution not to exchange competitively sensitive information. Exchange of information between competitors is somewhat widespread in industries in Korea, in part because each industry in Korea has a small community. Therefore, information exchange is somewhat widespread. An officer or executive that provides or tolerates with the knowledge on employees' exchange of information is punishable by imprisonment of no more than 3 years or by a fine not exceeding 200 billion Korean won. It is very important for CEOs and officers of foreign companies. Second, merge filing are required for mergers with large transaction value, even with a small target company. Under the current law, merge filing thresholds: first, parties' total asset or annual revenue is at least 300 billion Korean won, and the other party's total asset or annual revenue is at least 30 billion Korean won. Additionally, in the case of foreign to foreign transactions, each party's revenues in Korea must be at least 30 billion Korean won. And therefore, under the current law, if the total asset or annual revenue of the target company does not meet the 30 billion Korean won threshold, there is no obligation to file the merger, even if the transaction price is significant. For example, no duty to file when acquiring a venture company with a revenue of less than 30 billion Korean won, but has innovative technology at the price of 1 trillion won. But under the amendment, merger filing is required even when the target company is small, if two requirements are satisfied. First, the value paid or invested in consideration for the proposed merger must be greater than the amount prescribed by a presidential decree. And the target company or each specially related person, for example, affiliate, must sell products in the Korean market or be an active participant in the Korean market to the extent prescribed by a presidential decree, such as by holding research facilities or research manpower resources in Korea. Next, private persons are given standing to file an injunction. Under the current law, a private person injured from an antitrust violation cannot file an injunction with the court. Under the Korean law system, private persons have standing to file an injunction only when expressly stipulated in the law. For example, patent law, trademark law, Unfair Competition Prevention, and Trade Secret Protection Act. In contrast, under the antitrust law, there is no such clause or provision that can be the basis for injunction. Therefore, in the case of an antitrust violation, an injured person cannot file an injunction directly with the court and can only report the violation to the KFTC, seeking an injunction. But under the amendment, an injured person can file an injunction against unfair trade practices directly with the court. But injunctions can be filed only against unfair trade practices. Therefore, injunctions against other violations, such as cartels and abuse of dominance, cannot be filed. In such a case, it must be reported to the KFTC, seeking for an injunction from the KFTC. Next, administrative fines increased by twofold. There are caps for administrative fines under the MLFTA. In the case of cartel, the cap change from 10% to 20% of relevant sales, abuse of market dominance from 3% to 6%, and unfair trade practice and resale price maintenance from 2% to 4% of relevant sales. Here, relevant sales refers to sales from relevant products that the company sold in the relevant market during the violation period. Next, criminal punishment removed from some violations. Under the current law, criminal punishment can be imposed for almost all violations. But in practice, criminal punishment mainly imposed for cartels, a few types of unfair trade practices, and non-performance of remedial orders. But under the amendment, criminal punishment was removed with regard to conducts for which the need for criminal punishment is low, such as murder filing violations. Major conducts that may be subject to criminal punishment are abuse of dominance, cartel, unfair trade practice. Among unfair trade practices, unfair inducement of customers, coercive transactions, abuse of superior bargaining position, interference with business activities may be punished, and interference with KFTC investigations. And last, examinees' right of defense strengthened. First, right to counsel during KFTC investigation stipulated. Such a right was not stipulated in the current MRFTA, but only in its subordinate laws. But under the amendment, such a right is guaranteed under the law. Second, a greater right to access materials is guaranteed. The examinee or complainant can request access to or copies of materials related to disposition under the MRFTA from the KFTC. Under the current law, access is granted only when the person that submitted the materials agrees, or when the KFTC finds it necessary for purposes of public interest. But under the amendment, the KFTC must grant access except when the request is for trade secret materials related to leniency filing or information deemed confidential under other laws. Last, the KFTC must draft a record of statement when interviewing parties to an investigation. Under the current law, the KFTC does not have to draft a record of statement. These changes were made to strengthen the right of defense of the examinee. I provided a brief explanation about the recent changes to the MRFTA. If you have any questions, please ask your questions after the remaining sessions finish. Thank you.
Thank you, Charles, for your presentation. It is very insightful. Our next presentation is on the recent development of employment and labor union law. Edward Dong, who's a senior foreign attorney with 25 experience, will speak on this subject. Edward's principal area of practice are competition, labor, employment, and corporate. Prior to joining Yoon Yang, Edward spent 15 years at IBM as a head of corporate legal investigation for Asia Pacific, China, Japan, and various other roles. Edward is a former president of Korea In-House Counsel Forum and currently serves as a co-chair of the Compliance and Ethics Committee at AMCHAM. Also during Q&A, Hong Song will join us to address questions relating to this subject. Song He's a partner with 15 years experience, and his practice area includes personal matters, labor relations, criminal trial proceedings, and corporate litigation. In particular, he has a professional hands-on experience with labor relations as well as counseling on enactment and amendment of the rules of employment and the collective agreements.
Thanks, Henry. We recently had some notable changes to the Trade Union Act and the Labor Standard Act that merit our attention. Let me first cover the updates on the Trade Union Act. As background, in 1998, the International Labor Organization, which Korea is a member, declared a set of fundamental principles with the member organizations to implement. The 4 core principles and corresponding conventions are specified in my deck. Well, Korea has been late in implementing these changes until it was prompted by the European Union to act as mandated under the Free Trade Agreement with the EU. Therefore, the Korean government has made corresponding changes to the Trade Union Act, which will take effect on July 6th of this year to harmonize these discrepancies. Next slide. The current Trade Union Act prohibits the inclusion of non-employee members to the enterprise-specific unions. I use the word employee in a generic sense and use quotes around the word employee in this page because in the event that a dismissed employee challenges his or her dismissal at the Labor Commission under the Korean laws, such an individual is still considered an employee of the company until there is final adjudication at an appropriate forum. This provision prohibiting non-employees from joining a labor union was contrary to the ILO principles of letting unions determine membership requirements on their own without government intervention. Therefore, the Korean government removed this provision under the current amendment. This means that, as an example, a dismissed or laid off employee could now join or remain as a labor union member at their old companies as long as the union charter documents allow it. Labor unions in Korea, excluding the industry-wide unions, are usually formed around a specific business unit, physical location, and are enterprise-specific and therefore address the issues that are specific to employer-employee at a given company. Therefore, having a non-employee members in an enterprise-specific union could result in demands by members that are not employee-specific and harmful to the company or the enterprise-specific union employees. Accordingly, the government included a supplemental provision, specifically Article 5.2, that limited the activities of a non-employee union member to what they call actions that do not impair the employer's efficient business operations. Unfortunately, there is no clear guidance on determining what constitutes the scope of participation that does not impair the efficient business operation. Therefore, there could be future disputes surrounding this issue. Now, in Korea, where trade unions are generally enterprise-specific, it's been a common practice for employers to pay the salary of full-time union officers who exclusively perform union work. However, this practice raised concerns that a conflict of interest could exist, where the receipt of payment could adversely affect the independence of such union officer. Therefore, the existing Trade Union Act prohibited the employers from paying full-time union officers except under specific situations. The exceptions were broad and commonly used. Nevertheless, the ILO took issue with this explicit prohibition and asked it to be repealed, arguing that payments of wages to full-time officers should be left up to the labor force and management to decide. Therefore, pursuant to the ILO's recommendations, the amended Trade Union Act removed the prohibition on compensation to full-time officers and kept the exceptions. Therefore, the change is more cosmetic. Then the new amendment does not really fundamentally change existing practice area in this area. Next slide. Now let me quickly go through some of the other pending changes to the Trade Union Act. First, elimination of restriction on electing workers' representatives. The current Trade Union Act stipulates that officers of a trade union must be elected from among its members. However, the ILO had repeatedly advised the Korean government to repeal this provision, as the criteria regarding officer qualification was a matter to be independently determined by trade unions, and that the government should not intervene to dictate officer requirements. Therefore, the Korean government amended this provision so that officer qualification could now be determined independently by each trade union in accordance with its internal regulations. One caveat is that enterprise-specific unions are still required to elect union representatives who are employees of the relevant company. Second, good faith bargaining and non-discrimination requirements. If an employer consents to bargain with individual unions, such employer must bargain in good faith with every union that has requested for collective bargaining. It must not discriminate against any specific union. What this means is that an employer is obligated to faithfully bargain with each union without any discrimination. However, it isn't clear what constitutes a faithful negotiation or bargain without discrimination, so this remains to be seen. Third, merger of bargaining units. The current trade union only allows the separation of a bargaining unit upon consideration of various factors, such as working conditions, types of employment, and other factors. However, it is silent on combining various bargaining units. Therefore, in order to fill this legislative gap, the amended trade union provided a basis to combine bargaining units when it is deemed necessary by the Labor Relations Commission. Finally, restriction on occupation of worksite. Some of you may have experienced the unpleasant experience of your union employees occupying your business site. This right has been well tested in the courts. The courts have ruled that limited occupation is permissible as long as it does not hinder normal business operations. This right has been codified into the new legislation. Now let's turn to the Labor Standard Act. Next slide. When the Labor Standard Act was amended in March 2018 to reduce the maximum working hours to 52 hours per week, the government was required to come up with additional measures to fine-tune the system to remedy the difficulties experienced by the worksite by the end of 2022. The current amendment to the LSA is a result of such decision. Please note that changes specified in the amendment will take effect on April 6th of this year, depending on the size of the company's workforce. Currently, the existing system allows for flexibility for unit periods of either 2 weeks or 3 months. This latest amendment to the LSA provides another option, which is the introduction of another unit period that is more than 3 months but less than 6 months. This means that employer and employees could agree to work any work hours subject to certain conditions within the 3 to 6 month period, as long as the average work hour does not exceed 40 hours per week, provided, however, the work hour for any given week not exceed 52 hours. One notable restriction is that there must be a break of 11 consecutive hours between work days to protect employee health. Please refer to the deck for other conditions. Given that this flexibility may make it difficult to determine the work hours for each day in advance, the amendment requires work hours to be determined on a weekly basis and employees notified at least 2 weeks before the start of the relevant work week, except for on certain unavoidable situations. The company is obligated to discuss and agree with the representative of the employee group in writing before implementing the proposed work schedule. However, this does not mean that a company can reduce employee wages on non-recognition of overtime. Therefore, in order to prevent misuse of flexible working hour system, employers are required to submit wage equalization plan to the Ministry of Employment and Labor prior to the adoption of the flexible working hour system. As with other provisions in the LSA, employers may be subject to criminal penalties if they violate this regulation. The final slide, please. One other change to the LSA is extending the adjustment period of the selective working hour system. Given that work involving research and development of new products or technologies require a period of intense and prolonged work hours at times, the government provided an avenue for companies to negotiate with their employees to allow their employees to decide when to start and finish work. For example, an employee working at a research lab may decide to work 50 hours per week in 1 week, then work only 30 hours the following week. The LSA amendment allows company and employees to agree to work on a more flexible schedule as long as the average working hour does not exceed 40 hours per week or exceed 52 hours in a given work during a unit period. One key difference with the previous chart is that the company is not required to notify the employees of their work schedule. Please note that this is only for employees who work in the research and development of new products and technologies and limited for a period of at least 1 month up to 3 months. Similar conditions such as requirement for providing 11 consecutive hours of break time between workdays are also applicable to this provision. This concludes my presentation. Thank you. Henry, back to you.
Thank you, Edward, for your presentation. You made many good points. Our last presentation is on Ehs Matters. With many accidental deaths over the years, outcry come from publics and labor union. Korean lawmakers have enacted a new law that imposes significant criminal penalties against companies and individuals like yourself, executives, especially foreign companies that operate in Korea that has factories. This law will have a significant impact. Park Sung-ho will be speaking on this subject. Sung-ho is a senior foreign attorney with 20 years experience, and his main practice area includes corporate, general, M&A, entertainment, and sports law. Sung-ho has also worked in Hong Kong and New York. And also during Q&A, Lee Gu-nu will join us to address questions relating to this subject as well. Gu-nu is a partner with 15 years experience, and his main practice area consists of intellectual property protection, privacy protection, trade secret protection, including e-commerce and other technology, media, and telecommunication areas.
Hello, my name is Sung-ok Park and I'm a senior foreign attorney at Yoon Yang. Today, I will be giving a short presentation on the Act on Punishment for Serious Accidents, which was recently passed by the National Assembly. First, I will provide a short background of the Act. Then I will discuss the key aspects, and finally, I will provide you with ramification of what this Act can mean to you and what you can do to prepare once the Act goes into effect. Now, let me provide you with some color on the background of why this bill was passed. During the past few years, there has been a continued occurrences of accidents, both industrial and public, and that has led to a lot of public outrage. Let me give you some prominent examples. In the first caption, the article talks about a 28-year-old employee who fell down a railroad bridge during maintenance operation near a subway, which at that time was the 4th fatal accident of its kind to occur since 2013. More recently, in 2018, a 24-year-old worker was found dead in a power plant in Taean, where he got caught in a conveyor belt while working on a night shift, carrying out work alone that should have been done in pairs. Then there is the Seoul ferry accident in 2014, which is one of the greatest catastrophes in Korean history, resulting in the death of over 300 school children. And last year, it was reported that over 800 persons had died of industrial accidents. As such, many have questioned whether the existing regulations, which is the Occupational Safety and Health Act, is adequate, with the main criticism being that it is too lax in terms of its applicability and the punishment level, and too narrow in terms of who it protects. As a result, since June 2020, a total of 5 bills were introduced to the National Assembly, which mainly focused on holding business owners criminally liable for serious accidents. The bill was passed on January 8, 2021. The bill will come into force 1 year from the date of enactment, meaning January 8, 2022. However, with respect to those workplaces with less than 50 employees, the bill will come into force 3 years from enactment, meaning January 8, 2024. Now, let me go over the key aspects of the Act. The Act provides that a business owner or a person responsible for management has a duty to ensure occupational safety and health to prevent serious accidents and may be held criminally liable for failure to do so. In addition, companies may also be instituted a fine. Moreover, in case of a serious accident, punitive damages not exceeding 5 times the actual damages suffered may be imposed. Now, let me elaborate on each of the prongs. As a CEO, I would imagine that you will be most interested in the first prong, meaning the definition of accountable persons. Would this Act apply to you? The bill has expanded the scope of accountable persons to include business owners, and person responsible for management. A business owner is effectively like a sole proprietor, so it would not affect the audience, I believe. The Act defines a person responsible for management as someone who represents the business and has the authority and responsibility to overall manage the business, or someone corresponding to the foregoing in charge of tasks related to occupational safety and health. Now, there is some ambiguity in the reach of a person responsible for management. Under the existing regulations, if a company had a safety officer who was in charge of occupational safety and health, the CEO or other executive officers of such company would not be subject to liability in case of breach. However, under the proposed Act, it is likely that even with a safety officer, the CEO would be subject to the Act, since the proposed bill was enacted in response to criticism over the narrow reach of the existing regulations. Now, let me talk about the definition of serious accidents. The Act defines serious accidents as serious industrial accidents and serious public accidents. An industrial accident or a public accident will be deemed a serious accident depending on the consequences of the accident. If an industrial accident or a public accident results in the death of one or more persons, or many persons becoming ill or injured or ill, requiring treatment over a certain period of time, it will be deemed a serious accident. In case of an industrial accident, it would be deemed a serious accident if 3 or more persons contracted occupational diseases from exposure to identical risk factors. We have now talked about who the Act applies to and what the Act is designed to prevent. Now, if the Act were to apply to you, I will discuss what those duties are. The Act provides that the subject person has a duty to prevent serious accidents, to prevent hazards or risk in relation to occupational safety and health. Unfortunately, the bill does not elaborate too much on what this duty encompasses, and is very general. It does list 4 duties, which I will later elaborate when I discuss what you can be doing in preparation so that you can fulfill this duty. With respect to such duty, there is an increased scope of who you owe this duty to. Essentially, you now owe this duty to third parties in case of contracting, service provision, or assignment, but only if you are responsible for control, operation, and management of the relevant facilities. That means that the third party has to be performing that work under your control. We have now talked about who this Act applies to, what the Act is designed to prevent, and your duties. Should this Act apply to you, what would happen if you were found to have breached such duty, which resulted in a serious accident? In such case, you and your company could be subject to criminal liability. If a serious accident happens, and it resulted in the death of one or more employees, you could be subject to 1 year imprisonment and or a fine not exceeding 1 billion Korean won, meaning that you could be subject to both imprisonment and a fine. If the serious accident results in injuries or illnesses, you could be subject to imprisonment not exceeding 7 years and or a fine not exceeding 100 million Korean won. In addition, the companies may also be imposed a fine. If the serious accident results in a death, the company could be subject to a fine not exceeding 5 billion won. If the serious accident results in injuries or illnesses, the company could be subject to a fine not exceeding 1 billion won. In addition, the Act also provides that either a business owner or the company could be subject to punitive damages equal to not more than 5 times the actual damages suffered. But this only applies when there is intentional or gross negligence, meaning that if you have exercised due care and supervision, you will not be subject to it. There is an exception to the Act, which says that it does not apply to businesses which regularly employ less than 5 persons. And there has been a lot of controversy over whether this exception is just, because data shows that last year, a significant portion of the death resulted from businesses which employed less than 5 people. This chart will provide a recap of what I have just discussed. Now, I will discuss what this Act could mean to you and some points for you to consider. Before I do that, let me tell you the results of a survey done on domestic companies in connection with this Act. In a survey of over 600 domestic companies, not surprisingly, over 90% of the respondents said that they were against the Act, and over 95% believed that the level of punishment was too excessive. and over 91% believe that government support for preventing serious accidents is lacking. The Act contains ambiguous provisions, which I said earlier may cause confusion in the early stages of the Act, namely, who is subject to the Act and what is your duty should this Act apply to you. In case of the applicability of this Act, in case of safety offices, would CEOs also be subject to the Act? As I noted earlier, most experts believe that this will likely be the case. What happens if there are co-CEOs? Who does the Act apply to? But what is clear is that both CEO and companies will face considerable risk once Act takes effect, particularly since a fine may be imposed concurrently with imprisonment and the entity may be imposed a fine separately from the CEO. But before you get too alarmed about this Act with the imposition of criminal liability, note that criminal liability is imposed when a violation of one's duty to ensure occupational health and safety results in a serious accident. Therefore, a violation must occur, and there has to be a causal relationship between the violation and the serious act. What this means is that conversely, criminal liability is not imposed if you have fulfilled your duty to ensure occupational health and safety, notwithstanding the fact that as of right now, that duty is very vague. So, what can you, as the CEO, do to prepare your company so that it fulfills its duties? Well, it would be necessary for you to review your existing practices to ascertain whether it is adequate to ensure occupational safety and health. Now, let me end this presentation by telling you what these duties are as proposed by the Act. But let me preface by saying that it is very general, but it will give you a gist of what you will need to do. First, you will have to adopt measures to establish and implement a safety and health management system, which would entail human resources and budgeting necessary to prevent accidents. You will also need to adopt measures to establish and implement a prevention plan to prevent accidents from occurring. Third, you will need to adopt measures to implement matters ordered by a central administrative agency or a local government body, pursuant to applicable laws and regulations. Finally, you will have to adopt managerial measures that are necessary to perform duties pursuant to applicable occupational safety and health laws. Thank you.
Thank you, Sung, for your presentation. It's very comprehensive and helpful. We'll now have a Q&A section. Please send in your questions. Great. Thank you very much for sending all the questions. Thank you very much for presenters. The first question I have relates to antitrust matters. I want to ask Charles. The question is, under the amendment, exchange of information may be deemed a cartel conduct, as companies are advised not to exchange competitively sensitive information with competitors. However, collecting information is necessary for a company to operate its business. What kind of information are permitted to be exchanged with competitors?
Now, companies may exchange information that does not affect competition. For example, competitors are able to exchange information regarding publicly available information. For example, past or historic production data that does not affect a company's business decision, such as current or future pricing. And for example, information on legislation or government policy. But whether certain information is competitively sensitive would not be difficult to determine. Therefore, we recommend that companies prohibit any exchange of information with competitors as a rule and require the prior approval of the legal department when exchange of information is necessary for business activity. Thank you.
Thank you, Charles. The second question relates to the labor union employment matter. Maybe some you can address this. Question says, under the new amendment to the Trade Union Act, it seems that the company has very little rights, if any, to prevent a terminated employee from carrying out aggressive union activities at the company worksite. Is this the case?
Trade union membership does not automatically guarantee that a non-employee can enter a company's worksite at will without restriction. If a non-employee member were to enter into a company's worksite without the proper approvals, this would potentially fall under obstruction of work, trespass, or refusal to live under criminal law. As Edward said earlier, the new amendment limits the activities of a non-employee union member to actions that do not impair the employer's efficient business operation, and those activities that are specified in a company's internal regulations. However, if a dismissed employee becomes a union member, this will allow the trade union to raise a reinstatement of dismissed employee as a bargaining item. Also, given that the companies won't be able to take disciplinary actions against the former employees, since they are no longer employees, these former employees may become more demanding and the extent of their industrial actions may increase. Therefore, it is clear that the new amendment will increase the burden of employers. Thank you.
Great, thank you. Next question relates to the newly enacted act regarding punishment for a serious accident. Someone maybe could address this. The question is, if there is a designated safety officer, is CEO still subject to criminal liabilities?
Henry, that's actually a very good question because the Act does distinguish between a CEO and an occupational safety and health officer in the definition of a personal responsible management. Therefore, if an accident were to happen in violation of a duty, such duty, then the occupational safety and health manager would most likely be criminally liable. And in such case, there is a view that the CEO would be exempt. But, however, this runs counter to the original intent of the Act, which really was to make the CEO subject to criminal liability in case of such accidents. So, that's a good question, but unfortunately, the Act itself is very unclear, notwithstanding the definition. So I think we will just have to monitor and update and see how it progresses and how look at the actual wording of the presidential decree.
Thank you. I think the CEO still needs to be very careful.
Yes.
Even if there is a designated safety officer then.
Definitely.
Thank you. Next question. I think I could probably address this issue. It says, if a serious accident occurs, which law applies? Occupational Safety Health Act or the newly enacted Act on the punishments for a serious accident, or both?
Yeah. The final approved act has deleted the provision stipulating that the act takes priority over the other law, which had been proposed by some National Assembly members. Therefore, other law, including OSAR and law of criminal act of injury and death resulting from occupational negligence, may apply. However, the Act is likely applied in such case, since the subject person will be held criminally liable for the most serious offense committed and subject to corresponding sentence under criminal law Article 40. We call compound criminal law, which will be case under the Act.
Thank you, Vinod. Next question relates to the employment again. Someone maybe could address this. With regard to extending the adjustment period of selective working hour system for the research and development of new products and technologies, are there any points which employers must be aware?
As you guess, the amendment provides a lot more flexibility for the workers as well as their employees. However, this change initially raised some concerns in the labor community because some thought that extending the adjustment period could spread out the average work hours, which could then reduce the likelihood of triggering overtime pay. Flexible work hours during 3 months does not mean one can group the hours and average them over the same period for calculating wages and overtime. That is why the new legislation requires companies to calculate wages based on the number of hours worked on a monthly basis. Companies need to closely monitor employee work hours to determine whether overtime has occurred in any given month and make sure to pay them accordingly.
Thank you, Song. Next question, I want Charles to address this. Will the CEO be penalized when an employee or company engages in cartel activities?
The CEO may be penalized depending on circumstances. The CEO would be penalized when, for example, himself or herself participating in the cartel by, for example, attending a meeting for price fixing. Second, the CEO instructed an employee to engage in the cartel. Or third, the CEO received a report on the cartel or the potential cartel and approved or tolerated it. In contrast, the CEO would not be penalized if he or her had no knowledge of the cartel or had knowledge of the cartel but directed or discontinuous of the conduct, but the employee engaged in the cartel in violation of instruction of the CEO. We recommended the CEO seek legal advice when he or she is aware of any potential cartel activities of an employee. Thank you.
Thank you, Charles. I think this will be probably the last question we'll address. I want Knut to respond. What measures should currently be taken by the companies under the Elimination Act?
Yeah, thank you. The Act imposed duty to ensure occupational safety and health of business owners and persons responsible for management. However, the Act now merely stipulates duty in general term involved and stipulate even some specific duty will be further specified in enforcement decree of the Act in due course. Therefore, it is difficult for us to anticipate the scope of such duty. But despite foregoing, we may anticipate matter regarding the safety and health management system or fulfillment of duty pursuant to safety and health-related law would follow the existing OSHA regulation on safety and health standards to extend corresponding thereto. So it would be necessary for company to monitor the legislative development, such as enforcement decree of the Act, while properly checking and complying with the relevant duties stipulated in the existing law. Thank you.
Thank you. I have one last question to add, relates to Donnery. Is there a right to ask the authorities to wait for lawyers?
Well, that's a good question. I guess a couple of things. One is from personal experience in the past, and also from discussing with my colleagues here at Yoon Yang from the past and others, is that it's important for the company to request to see the actual documentation. So basically a search warrant or what type of documents that they do have, the authorities, and they need to show you that. Now, and obviously you should have a Don Ray guidelines, and every good company should have a robust Don Ray guidelines that you should prepare with your external counsel as with your in-house lawyers, so that I mean, all companies, unfortunately, major companies will experience that in some time during the duration of the company. So now, once either the regulators or the authorities that do come, yes, and you should ask in a very polite manner to the lead authority and ask them to say, can you please hold on? We have counsel, and we'd like to have our counsel attend. Now, the problem is that it's not a legal requirement for them to wait. And it's unfortunately at times people do get aggressive, and if they give you and they show you the warrant, and you have to cooperate basically. And it's important that you do not obstruct justice, meaning you do not obstruct, and there are certain situations where people try to evade and share documents. Absolutely, I mean, I know that AMCHAM members, most companies will not do that. So it's important to cooperate. Now, I think it's also important to make sure that you have, to the extent you develop a relationship with the regulators, with the lead person, so that be it the in-house counsel or the person, the chief operating officer, to that extent, have place for the officers and the authorities to come and basically set up shop at your own location for that day that they're there. Then also try to develop the relationship so that you will be able to shadow the officers to make sure that you get a sense of after when this is going on, that it's not you're not in the dark and you're getting information from your field people as to what the officers are looking at and possibly seizing. Now, that's not an absolute requirement, and the officer could reject that option, but I think it's important as soon as you find out that you call your external counsel, like ourselves, if we have the experience, and that we have the relationship and try to hold off the court, so to speak, until people get there and be able to have the relationship and assert rights that you do have. So I think the key is that you basically cooperate to the extent that you are required to do so under law, but work with your counsel to handle the situation. And preparation is obviously the key. So thank you, Henry.
Thank you, that's very helpful. Thank you for joining us today. We hope that we have provided you with insight to the change of the law. This ends our presentation. We wish you a safe, healthy, and very best 2021. Thank you very much.